The Federal High Court in Abuja adjourned till Wednesday, March 9, to rule on the no-case submission filed by the PDP spokesperson Olisa Metuh. At the resumed hearing, the counsel to Metuh, Onyechikwazu, told the court that based on what the prosecution had filed, there was no case submission. He said a point of law which was filed on February 24th should be considered as a reply to the submission of no case made by the defense. But the prosecuting counsel, Silvanus Tahi, said he received a written address and had replied to it. Justice Okon Abang then adjourned the matter for either ruling or judgment on the no case submission.
The highlight number one is that most of you are witnesses to the trial of the presentation of the evidence of the witnesses, at the end of which the defense counsel feel that Chief Olisa Metuh has no case to answer on the basis of the fact that the evidence given it does not relate to the charges framed against him, and that the monies alleged to have been seen in his account we are tied by the evidence of the witnesses to specific expenditures relating to PDP and to the image of the president, and most importantly, expenditures of the past general elections. At the end of the evidence of the eighth witness, we felt that he has no case to answer and there was no need for that. So the judge directed that our submissions be in writing, which we did, and we filed it and served the EFCC. And they in turn filed their own reply. And from that their reply, we also saw loopholes on points of law, which we also filed and served them. The judge has adjourned to the 9th of March for two things. He said, if he upholds our no-case submission, it means that Chief Olisa Metuh will be discharged and acquitted. And if he does not uphold the no-case submission, it means that Chief Olisa Metuh will be called upon to open his defense the same day. And he also ruled that in that case, the trial will be on a daily basis.
You know, they filed a no-case submission, arguing before the court that the evidence placed by the prosecution in proof of their case does not warrant them to open their defense or to enter into their defense. On the other hand, we contended and argued before the court that we called 8 witnesses who gave oral evidence. We tendered gamuts of documents which were all admitted in evidence as exhibits before the court. Now, given the oral and documentary evidence we proffered before this honorable court, it is our belief and argument that it is only fair that they enter into their defense to tell their own side of the story. So on the basis of the responses or the addresses next month, March, for ruling, whichever way it goes, if their no-case submission is overruled, then they will enter into their defense. If it is upheld, they will be discharged and acquitted.